Welcome to the Lost and Sauce podcast, your go-to for breaking down today's most compelling legal stories that are shaping the foundations of tomorrow. I'm PJ.
And I'm Harper. Our special guest today is Etan Mark of Mark Migdal Hayden.
Hey guys, thanks a lot for having me on the Lost and Sauce podcast.
Welcome, Etan.
Stay tuned, everyone. We will be picking Etan's brains later.
Today, we're diving into a case that brings together iconic art, copyright disputes, and allegations of racketeering. Let's talk about Michael McKenzie, DBA American Image Art vs. Artists' Rights Society Incorporated, Morgan Art Foundation, and others, pending in the United States District Court for the Southern District of New York.
If you've ever seen the famous love sculpture with the tilted O or its cousin, the Hope image, then you're already familiar with the designs at the heart of this case. But behind the art lies a legal battle over who has the right to profit from these cultural icons.
So PJ, let's start with the basics. Who's suing who, and why?
Michael McKenzie, an art publisher who collaborated with Robert Indiana, the artist behind the Love image, is suing Artists' Rights Society and Morgan Art Foundation. He claims they falsely asserted copyright ownership over the Love image and used this to rake in millions from licensing deals.
Here's the kicker. McKenzie argues that the Love image isn't even copyrighted. According to him, it's in the public domain because it was widely reproduced without copyright notices.
And McKenzie's own creation, the Hope image, has suffered financially because of these alleged misrepresentations. He says the defendant's actions undercut his ability to license Hope and harmed his business.
Let's talk about the legal claims McKenzie brought to court. First, he alleged violations under the Lanham Act, false advertising and false designation of origin. Essentially, he said the defendants misrepresented their rights to license the Love image.
He also threw in a RICO claim, accusing the defendants of engaging in a racketeering scheme to profit from these fraudulent copyright claims. According to McKenzie, this wasn't just a licensing dispute, it was a coordinated criminal enterprise.
Bold accusations. But as we know, RICO claims require strong evidence of fraud and direct harm. Did McKenzie deliver?
Not quite. The court dismissed both claims, and we'll get into why.
Let's start with the Lanham Act claims. The court relied on a landmark case, Dostar Corporation v. 20th Century Fox, which clarified that false claims about intellectual property rights don't fall under the Lanham Act. The judge essentially said, this isn't a trademark issue, it's a copyright issue.
Right, and even if the Lanham Act applied, McKenzie failed to show how consumers were deceived into thinking the defendants owned the Love copyright, or how that deception directly harmed his business.
Now, what about the RICO claims?
The court dismissed those too, citing a lack of specificity. RICO cases require detailed allegations of fraud, specific dates, actions, and how those actions caused harm. McKenzie's claims were too vague to meet that standard.
And then there's the timing issue. The doctrine of laches barred McKenzie's claims because he waited too long to file the lawsuit. The court noted that the alleged misconduct spanned decades, and McKenzie had been aware of the licensing disputes for years.
We invited Etan because of his fascination with RICO cases. Etan, what was it about this case that you found interesting?
I'm going to particularly focus on the court's dismissal of the RICO case on the basis of the absence of proximate causation. Proximate causation is very often the death knell of a RICO case, the failure to allege proximate causation, because it really requires more than some kind of ancillary injury. The injury that's alleged really has to be a direct result of the predicate acts that one alleges in a RICO case. So here, in this case, the court believed and ultimately found that it was too attenuated, that the injury was too attenuated relative to the alleged bad acts. And the way that the court sort of got there is because they looked to see who really at the core of this was the injured party. Who was the first injured party? And what the court determined was that the first injured party really was the licensees, and it really wasn't the plaintiffs. And only once you went down a couple of levels, so to speak, were the plaintiffs injured as a result of the predicate acts, which does not meet the standard of proximate causation.
Why is it so difficult to prove a RICO case?
The ANZA case, ANZA, ANZA, is really the case that a lot of courts rely on. It's a U.S. Supreme Court case that has made alleging proximate causation in RICO cases particularly difficult. And to sort of put the exclamation point on this, the court also found that there was an intervening cause, or arguably intervening causes, that could have caused the injury here, which I think gave the court more comfort in rejecting the allegations here. So, all in all, not surprised to see this case being dismissed on the basis of the absence of proximate causation. It's a very common pitfall in these RICO cases.
How do you approach RICO cases in your practice?
When I'm looking at a RICO case, for example, on either side, the plaintiff or the defense side, one of the first questions that I ask myself is, has the plaintiff alleged proximate causation? And when I'm looking to sue somebody for RICO, I ask, has my client truly been directly harmed as a direct result of the alleged predicate acts?
Thank you, Etan. So, what can we take away from this case? First, the line between copyright and trademark law is crucial. Misrepresenting copyright ownership might be unethical, but it doesn't necessarily violate the Lanham Act.
Second, RICO is a high bar. You can't just say, this feels like racketeering. You need concrete evidence of a coordinated scheme and direct harm.
And finally, timing matters. If you wait too long to bring your claims, courts may dismiss them, even if the underlying issues are serious.
This case also underscores the complexities of intellectual property in the art world. Artists, publishers, and rights holders all need to carefully navigate copyright, licensing, and contracts.
That's all for today's episode. Michael McKenzie's case highlights just how contentious and complicated the business of art can be.
If you've got a legal story you'd like us to cover, reach out. We're always here to explore the twists and turns of today's legal battles.
But remember, we are not able to give you legal advice.
For that, you need to contact your lawyer.
Nothing we discuss should be construed as legal advice.
And anyway, you should never take legal advice from kids.
Thanks for tuning into the Lawsome Sauce podcast.
Until next time,
stay curious and stay informed.
Have a great day, everyone.